Аделия.
Да, Николай, здравствуйте. Я Аделия Диатуллина из Education Office с Сколтех. Я просто захожу и смотрю, все ли в порядке, нужна ли какая-то техническая помощь. Я так
Всё
понимаю, вы
отлично.
все в комнате ожидания, да? Все
Ну
студенты
вот
пока.
у меня 3 человека из 8 в комнате ожидания.
Ага, хорошо,
Ну, сейчас
ладно.
я тогда я на вас не обращаю внимания.
Да-да-да. Просто если
Вот,
нужна какая-то помощь, можете меня кликнуть. Я минут 15, наверное, 10 буду просто, если нужна будет.
Все
Ага,
отлично.
все, спасибо.
Тогда мы начинаем потихонечку.
Мгм.
Good morning, everybody.
Good morning.
Is it possible to switch your camera on at least for a second, just to let me see you this once? Okay. There are not so much of you. I saw 8 people enrolled for my course. 4 is now here. Nevertheless, we will spend 4 days this week in about 2 hours a day and discussing the issues of privacy and personal data protection and how all this stuff influenced on our life. You may switch your camera off right now. I think it's okay. Just a few words about myself. I'm a lawyer. My main occupation is IT and communication law. I work for law faculty of Moscow State University, where I'm the head of laboratory for legal informatics and cybernetics. Why I'm here? Let me start my presentation now, my slides now. Just give me just a second. Do you see my slides?
Yes.
Great. And one more question. Do you hear me well?
Yes.
Okay, great. Just a second. There are not so much of you here, so if you have any question during his speech or my presentation, don't hesitate to turn your microphone on and to interrupt him. Okay, so great. Here is my position in the Moscow State University. And here on this slide, you can see all the blocks of our course. The first is privacy, private life, the certain area of our life that is protected by the law. Tomorrow we'll speak about personal data protection, or in English terms, data protection. The third talk will about big data and how it interacts with privacy and personal data protection regime. And the fourth day of our discussion, of our meetings, will be devoted to the issues of limits of the law. It means what laws can regulate and what they cannot. Just to give you the idea why I am giving this talk to you, as far as I understood, you are not lawyers. Because maybe 3 years ago, when I started this course, it was a kind of legal fiction. To explain you the ideas, how it worked several years ago, how it's thought to be working now. But this year, I mean, the year 2020 put everything on its places. Privacy is part of our life. It's our vital interest to protect the certain data about us, to use a certain channel of how information about us is being spread within the internet, within the media sphere, within the cyberspace. This slide, I think, give you some backgrounds of this course. That was my introduction to what I'm doing, to what I will do here on this course, and why I'm doing it. And maybe you can introduce you will introduce yourself. Just a few words. What I major in, and why are you here? Could you please tell me just to so I have the idea of what you are interested in this course, please. Mohammed, please.
Yes, can you hear me well?
Yes, sure.
Okay, thank you for your good introduction, and I'm interested for this course. First, I'm Mohammed Defalla from Alexandria, Egypt. I joined a data science program 2020. So actually, my work is interested in data, in every form of data. Images, text, rows, anything about data. So I need to have a glance about the privacy, protection, security of data. What are the responsibilities? What are the laws? What are the rules of that? So I think this course is appropriate for me.
Great, thank you. Who is the next? Okay, then I'm a kind of instructor here. I'll ask you, Ekaterina Kuzmina, could you please tell a few words about yourself?
Okay, my name is Ekaterina. I'm from program course 2, and I choose this course because I just interested in the protection of data. I know I think that now we all have to have some literacy about these topics, and also as far as I understand, there will be some dilemmas about what's right and what's wrong, how we just will think about some interesting topics, and that's cool too for me.
And what's your major area of study identification? Sorry.
High performance programming, I think.
Okay. Okay, Karina, thank you. Evgeny, how does it?
Can you hear me?
Yes, sure.
I'm from data science program 2. Me myself, I'm from Moscow, from Moscow Institute of Physics and Technology, and also in my previous studies, I've been working at MIPT. I've passed a course on information security and learning not only technical aspects but also legal aspects of data protection would be interesting for me.
Great, thank you. Maxim?
I'm second year PhD student, and I'm interested in that course because I heard that personal data is selling on the left and right everywhere, and I witnessed one case where it was used by other people to take credit as another person. So I wanted to know more about the privacy and personal data protection.
And what your major area of study? Sorry.
Physics.
Physics.
I'm Tatiana, and I'm graduate from Moscow State University now. I'm first student of material science program, and I designed perovskite solar cells, and now I design sensors, and I consider that this course is I choose this course because this topic concerns each of us now, and I consider it's important to understand personal data protection.
Great. We will speak about the privacy by design today a little bit later. So you choose a very relevant topic. Okay, thank you. Dmitry, who had just joined us. We are on introduce ourselves stage. So very nice you join us. I'm Nikolai. I'm your instructor here for this course. I'm from Moscow State University, where I'm a lawyer and the head of a laboratory. Could you please tell us just a few words about yourself? What is your major area of study and why you are interested in this course?
Hello, I'm from space and well, I'm previously studying physics, and well, it's just curiosity. I just want to know how my personal information travels through internet, and can be sure that it is safe. Well, I want to know some law behind this. So what information can be what information can be analyzed by the companies that have my personal data? So like this.
Great, thank you. Just to say, I'm not going to speak very much about rules, because the best way to understand rules and laws is to tell stories. That's why my course is about stories and cases, to explain how privacy works, why it's designed in the way it is. We need to go through not all, but the main stories which gave birth to privacy and that were pivotal to the privacy legislation, because all the laws, all the rules are just in the people's heads. There are lots of laws outside for about the Roman laws. We the lawyers, some of lawyers still know what Roman law is and what it was. But we don't treat it as rules, as laws. They are not in our heads, and they don't govern our day-to-day behavior. That's why we need to study not the rules, not the laws, but the way it is, the way they are recognized by people throughout the world. And the first story to start with, it's about this camera here on the left. It dated back to 1888, when it first was introduced to the North American market. It was a Kodak camera by the Eastman Kodak company. And it was the first camera that can be put into a pocket and taken out of the pocket to make a shot. Before that, any person who wanted to be pictured needed to go to the photo workshop to prepare for about an hour or so, to put makeup, light, to wait in line, then to sit up to 15 or maybe 30 minutes before the camera, and then wait several days until their photos were printed. Kodak camera changed at all, because it's not only very easy to wear it just in the pocket, to use it just to get out of the pocket and press one single button, and also it had replaceable film there, and no special knowledge was needed to operate this camera and to make photos. You just need to put this replaceable film into the camera box, make some shots, and then bring this film into any shop where the photos can be made. And this device gave birth to two very important institutions of our days. The first is the privacy, what we're talking about. The second is so-called yellow press, because before this, all the press, all the newspapers and magazines were without pictures, or they were drawn pictures, not photographs. And here the story comes. One very honorable person, his name was Samuel Warren, was engaged with the daughter of another very honorable person. I don't know whether it was congressman, or whether he was a congressman of the United States at that date, or maybe a little bit later. But again, all this family was very honorable, and they really enjoyed the dignity of being the elite part of the United States society. And with all these feelings, they were performing marriage in the church somewhere in Chicago, and this very marriage was filmed on this Kodak camera. And on the next day, the photographs from this marriage appeared in the newspapers somewhere in Chicago downtown. From the point of view of a modern person, nothing wrong had happened, because it was a public place, a church. It was a public procedure of wedding. Again, it was some kind of public interest into getting to know what was happening to this congressman or would-be congressman. But this groom, this person who married this girl, Samuel Warren, was a young and prominent lawyer, and he decided that something was wrong. It takes him about a year to elaborate a legal position about it, and he called it, along with his friend Samuel Warren and Louis Brandeis, that was he colleague to the law firm. These two lawyers invented the new right, the new subjective right. They called it the right to privacy. And here on this slide you can see the first birth, because there were several to the right to privacy. The initial article in the Harvard Law Review, 1890, written by these lawyers, Samuel Warren and Louis Brandeis. And this article stated three main theses. First, that privacy is not property. Why it's so important? Because again, it was the United States, and the United States Constitution was in force for more than 100 years after this. The United States Constitution and all the laws of the United States protected property, and also protected so-called intellectual property. That means works of authorship, or some paintings, or texts, or novels, etc. And also the Constitution and all this, the commercial laws protected rights derived from contracts. But what was stated by the Samuel Warren and Louis Brandeis in this article states that privacy is not property. Privacy had no any rules in the contract law. It's a brand new right. It does not have any rules in the previous institutions, and the aim of it is to protect dignity of honorable men like this very respectful author was. Also, there are two other theses describing what this kind of right should be. It should be the right to be left alone. It means the right to eliminate any intrusion into private life, and the right against all other world. Speaking in modern terms of law, it's called an absolute right, because there are two kinds of rights, so-called relative or related rights. It means, like in a contract relationship, one party of the contract relationship has a right, has rights on the other side, and vice versa. Unlike them, so-called absolute rights are against all other words. Being when we enjoy the right of property, there is a right against all other world. No one can take our property out of our belonging. So these three concepts, three main theses, form the initial right to privacy, as drafted by Samuel Warren and Louis Brandeis, the right to protect the private life, indignity, the right to be left alone, and the right against all other words. It means yellow press, some paparazzi, etc. And this is what our story, our first story, led to. Do you have any question about this? Okay, great. Please know that it's more than 100 years ago, 1890s. The second story about this was about the privacy, was about wedding again, but very unlike wedding, because initially the bride to this wedding was a prostitute. Again, again in Chicago, yes. Her name was Gabrielle Darley, and whether we like it or not, she was a prostitute somewhere on Chicago streets. The story began with the fact that Gabrielle Darley killed her client, just in public, just in the street, with publicly, the public interest to it, to this case. She was brought to a jury, to a court, tried, and due to efforts of her defender, she was not brought to jail. She weren't imprisoned. She, as far as I know, was found guilty, but with some excuses, and she avoided going to jail. After that, after she was tried by the court, she moved to Arizona. It's a little bit far away from Chicago, and then she found a man and decided to marry him. It's worth mentioning that she still uses her real name, Gabrielle Darley, but for sure her groom didn't know about any facts of her very remarkable past. Okay, but the scene of this girl killing her client somewhere in the street of Chicago. The trial itself was a very picturesque story, and it was roaring 20s in the United States, when Hollywood came into its golden age. And for sure, a script was made on this Gabriel Dairley story, and a film was shot called The Red Kimono, exhibited in moving picture in all the United States, and also in Arizona, where Gabriel Dairley lived at the time. And the thing is that in this script, in this movie, this woman was shown under her real name, and it came to all the people of this Arizona town where she lived, and everybody got to know that this woman has a very remarkable past story, not maybe allowing her to live in the same life and with the same dignity as it lived before this Arizona town. Gabriel Dairley, at that time, she was married, and her name was Gabriel Dairley Melvin, applied to court, and she based her claim on the right to privacy. Maybe you can assume that these two stories I was giving to you are very unlike. The honorable man marrying the daughter of senator, and the former prostitute trying to protect to protect her very flimsy, let's say, life from being pictured in the Hollywood movie. But the court ruling was very interesting, because the judge said that everybody in the United States has the right for a second chance. It's a very important statement for the United States, because really in the business area, in the business life of the United States, really everyone has a second chance. Unlike our institution of bankruptcy, which kills a person's life, which doesn't allow anybody to start a business again in 5 years, the bankruptcy institution in the United States is just to cut off the claims of private creditors and to start this business or some other business again. And that's why, and that's one of the most prominent, one of the most powerful pillars of the United States prosperity. That's why this approach was used in the privacy dispute. Everyone has a chance, has a right to second chance, to start from scratch, even in so uncommercial area of life like private life is. And the court ruled that not only a lead person, not only an honorable man, but also a person like Gabriel Dairley can enjoy the right to privacy. And in this way, it comes to the book. It's just a book, not a law, called Restatement of Torts. In the United States, there are some laws, but much more important than laws are court rulings. And these court rulings, court decisions are gathered into some codes or binders called Restatement of Torts here. And in 1939, in this book, Restatement of Torts, a Prosser, is another very prominent American lawyer, stated the tort of privacy. It means a violation of some subjective rights that is called their right to privacy. And that's what you can read on the slide. There is a main, this is the gist of this tort: a person who unreasonably and seriously interferes with another interested in not having his affair known is liable to the other. The core words here is interference with another private life. It means is not in somebody's affairs or somebody's pictures. That's what we discussed right now in the stories. A likeness, it means an appearance, a picture and image of some person on the one side. And affairs, it means private sphere, private life, private behavior, what we share with our friends, what we do, what we do in our family life, etc. These kind of relationships are protected by this tort, not by the law, because at that time there was no law protecting privacy in the United States, but just by the court systems, by the court decisions. And there are four main ways of interfering privacy, of violating privacy rights. You may also see it on the slide. First is unreasonable intrusion upon the seclusion. Do you know what seclusion is? Do you have any idea? What's the most the more modern word for this? Seclusion. What is this? It's not just a question, it's a way to understand. Do you hear me and do you understand me?
We do hear you.
And then what seclusion is, what a modern replacement of this word?
Maybe outcasting.
No, the modern replacement is shelter. Is somewhere you can hide from all other world.
Maybe I can I talk?
Yes, sure.
Okay. Maybe seclusion is like isolation.
Yes, sure.
Or yeah.
Again, the privacy is the right against all other world, and the right to be left alone. And where can a person be left alone? In the seclusion or in some shelter, into some isolation? Yes, sure. So any unreasonable intrusion into this shelter, into this isolation, shall be prohibited by the laws, again, by the courts. The second is the appropriation of the other's name or likeness. It means when somebody company or some physical person uses a person's image or even appearance, like in Charlie Chaplin image, it's enough to use his mustache to interfere into privacy of Charlie Chaplin. The third way of violation is unreasonable publicity given to the other's private life. Again, it's Gabriel Daly case. It's a publicity for unreasonable, for no reason given to her private life, because the only thing this Hollywood company should do to protect her private life is to change her name. But for some reason they used her real name, and in that way they violate her privacy. And the second form of this tort is publicity that unreasonably placed the art in a false light before the public. Again, maybe in some kind it's a case of Gabriel Daly, because it was about her past life. The situation that happened more than 10 years before that, and it's really placed her in a false light, because now and the days of court trial, she was just an ordinary wife of an ordinary people living their silent life in a very silent town of Arizona. Okay, remember these 4 forms of this tort, and please remember the year, because year is very important here. It's 1939, and it's somewhere in the North America, and then it's the second burst of privacy, where it's for where it was put into form of tort. Tort is the main pillar of American court system. It's a ground for any court decision in civil rights. Okay, let's go further. Do you have any question about this case? No. Is it okay to you the way I describe the case? Because again, I'm a lawyer, you're not. Maybe I use some legal wording that that's not understandable for you. Please tell me this if you are okay or if you are not okay with this.
Could you please explain what is proser and tort? I just don't understand.
Proser is a person, a lawyer. He is just the author of this book called Restatement of Torts. Restatement of Torts is the name of a book. Tort is the ground of a court's decision. There are several torts in the United States legal system. For example, the tort of violation of property is it means that somebody steals some property, something, or some gadget from you. It's for violation of property tort. The violation of privacy tort, it means that somebody interferes and or violates the right of privacy. The tort of violating the contract tort is something not under the contract. It means not performance of the contract, or maybe not fulfilling the quality required by the contract, etc. There is no exact translation of the word tort into Russian, so I can't give you any Russian variant for it. Maybe it's право нарушение, but it's not, because it more than violation of law or trespass in English. So the tort is something wrong tried by the court, and the decision of the court is to find somebody liable for this doing wrong. So maybe the most close analog to tort is wrong. Something wrong is done, and it's a tort.
Thank you.
Mm-hmm. Okay, let's go further. Please remember the place, United States. Please remember the date, 1939. And please remember what we were talking about, kind of dignity, commercial interest, etc. And the next story is about 20 years later. This person name was Ted Lander, and he was a baseball player, very, very famous. The story is about this baseball player and two chewing gums manufacturer. Again, it's two symbols of mid 20th century's America: baseball and chewing gum. Ted Lander concluded a contract with a chewing gum manufacturer, allowing this businessman to use ball players' photograph in connections with the sales of plaintiff's gum. It means that in aims of advertisement and promotion of chewing gum, the photo of this man, of this baseball player, can be used. After this contract is concluded, and maybe after some photos of Ted was spread on the market, next another chewing gum manufacturer called Tops Chewing Gum started to use the photo of the same man in order to promote their chewing gum. So there were two chewing gums manufactured and only one baseball player whose photo was used. And the thing is that the contract allowing to do that was concluded by this baseball player only to one chewing gum manufacturer. In this case, there was a claim was made from the one chewing gum factory, Helen Laboratories, to the other chewing gum laboratories, Tops Chewing Gum, on the basis that they have not any legal reason to use the appearance, meaning the photo of Ted Lander in their advertisements. The thing is, what is unlike in this case, comparing to two cases we discussed before, it's what's written here on the slide, because Ted, in this case, gave his explicit consent to use his appearance in public life. So there is no privacy issue because there is no private life, no shelter, no seclusion where Ted wants to hide in. There is no any right to be left alone because he didn't want to be left alone. No, he wanted to be everywhere on the advertisement. But what's written here and what's the gist of this new chart is that he didn't receive any money for his appearance being used by the other chewing gum manufacturer, and this case led to another right covering mainly the same area of life. It's called the publicity right. We were speaking about privacy rights, it's something private, something allowing to hide from all other world. Now we're speaking about publicity rights. It means the right, an exclusive right to get money from your appearance, from your name, or some facts connected to you being used in any commercial activity. What do you think? Do we have a kind of publicity rights in our Russian laws? Any ideas? Does Russian law give us a right, or maybe certain rights, to claim money for our appearance, our photos, our names being used in advertisement, for example? Please, guys, I just want you to interact with me.
I actually have no idea, but I think there should be.
Yes, it should be, because this case, all this person you can see on TV, on your screens of smartphones and computers, they earn money for them. Here in Russia, as well, and somewhere in Europe and in the United States. And this worth mentioning that this guy, Ted Langer, gave birth to this publicity rights. We enjoyed for more than 50 years, even here in Russia. That in Russia it's called the right to image and the right to name. There are two rights for this, covering our exclusive power to give our consent on the use of our name, if our name is used, or for use of our image, and claim money for this use. So if some of you is lucky enough to be pictured in some advertisement on some movie, you can claim money for the use of your appearance. It's protected by the Russian Civil Code. Okay, let's go a little bit further. And look into the document called Universal Declaration of Human Rights. Do you know when this document was adopted? Any ideas? When the Universal Declaration of Human Rights was adopted? Okay, do any of you hear about the document called Universal Declaration of Human Rights?
I have heard.
Great.
Yes, I do.
It's a basic document covering so-called post-war structure of our world. Because after the Second World War, United Nations decided to put on paper some very crucial things needed to prevent universal wars or world wars after that. And this, there are two documents constituting these principles of the post-war world. One is the United Nations Charter. It's the main document underlying the work of United Nations organization. And the second is Universal Declaration of Human Rights, covering the rights of any individual anywhere in the world. This means it's in the United States, in Europe, in Russia, in China, in Egypt, and in South African Republic, and somewhere in Turkmenistan. This Universal Declaration is really universal because it's enforced anywhere in the world, covering any person in the world. And Article 12 of this declaration is about privacy. Why it was so important to put this not well-known right into the very universal declaration? Again, the right to privacy was invented by the American lawyers to protect their dignity. It was then extended to very questionable person like Gabriel Daly and so on. And after 50 years, it's very small period of life for any legal construction. We found it into a very high level document called Universal Declaration of Human Rights, the main post-war document acting up to now. Well, why do you think it was their right to privacy became so important? Any ideas?
Sorry, but I didn't understand the question.
Why do you think the right to privacy became so important that it was put into a very high level document called Universal Declaration? We just spoke that for previous years, the right to privacy was for United States businessmen and prostitutes, and now it's for everybody. Why? Okay, do you realize that during the World War, during the Second World War, any person can be killed,
Yes.
murdered by only the fact that he or she is a Jew? It's a very small piece of information about a person. My grandmother and grandfather were killed just by the fact that they were Jews. They didn't do something wrong. They were just moderate people. It's again the right to privacy protects information about individuals. And the Second World War showed how important it was to protect information about individuals, because the information about us may inflict our death. It's not only during wars. If you when you looked about our on my first slide, it's what's happening right now. Some protests in our countries, the work of journalists, the work of law enforcement agencies. It's since the Second World War, it's about information, not about people themselves, but about information about them. And in this case, the right to privacy protects our life and our well-being. And that's why this right is put in the very high level document called Universal Declaration of Human Rights. Because not only this document touches everyone, but this right has touched everyone. It's important for everyone. And to underline this thing, a very specific wording was used by the drafters of this document. There are only 3 articles in the Universal Declaration of Human Rights, starting with the words "no one." So no one means really no one. If an alien comes to the Earth, they still will be covered by this Article 12 of the Universal Declaration of Human Rights. Can you bet what are 2 other articles of this Universal Declaration, starting with the words "no one"? It means the most universal protection from not doing something. What are the 2 other articles starting with "no one"? Any ideas?
If thinking logically, maybe something about killing people or stealing from them.
Being frank,
It's like universal.
Killing people is allowed for some reason during wars or capital punishment, and kind of abortion. So unfortunately, maybe unfortunately, human life is not protected by the words "no one." So it's just to underline the privacy for the drafters of this declaration was more important than even our life. And what are 2 others that cannot happen to anyone? Intrusion to personal privacy, and what other cannot be done to any person in the world?
I'm not sure, but maybe the seclusion that discussed before.
No, seclusion is just a shelter, some place to hide.
I think,
but
yes,
you're close. What cannot be done to any person in the world?
I mean that no one should violate someone else's isolation or seclusion. That was my intent.
It was written in this very article. The right to privacy, it's no arbitrary interference. It means that no voluntary violation of someone's seclusion, of someone's privacy. It was written here. What are the two other things that cannot be done to anyone in the world? What you want for to be done to yourself in no obstacles, in no situation? I'm sorry. Just think.
Using tools.
Using tools to what?
No one shall use someone else's tools.
Tools? Could you please explain?
Tools like my pencil. No one should use this pencil without executing me.
I'm sorry, I don't understand what.
Okay, no problem, no problem.
Okay, the first is slavery. No one can be enslaved to become a slave. Unfortunately, it's still actual because there are more than several million slaves in the world. But again, no one under the Universal Declaration of Human Rights can be put into slavery. And what is the third one that cannot be done to anyone in the world? Again, no idea. No one can be tortured. There are 3 articles starting with no one wording in this Universal Declaration. First, no one can be enslaved. No one can become a slave. The second is no one can be tortured for any reason. And the third one, no one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence. Though these 3 are the most important things the humanity brought out of the Great War, of the Second World War. It's a little bit sad story, but let's move further. And here is the wording of the Constitution of the Russian Federation. It's in Russian, and it said that again, каждый, means everyone, have the right to inviolate private life, of family life, and protection of his or her honor and fair name. It's almost the same wording as we just saw in the Universal Declaration of Human Rights. So it's a kind of knowledge, a kind of universal knowledge that you may find anywhere in the world. That privacy is protected. Since this Kodak camera back to 1890s and through the World War, humanity recognized the new right, the right to privacy, the right to be left alone, the right not to experience any violation, any intrusion into private life. Any questions about these stories we discussed before? If not, we can talk about the design. I promised to do this, and now I'm ready. Do you understand what design is for privacy? Because it's always needed to explain it for lawyers. Tatiana, am I right? You studied design, right? Material design.
Yes, but I designed perovskite solar cells. I started, so okay, but I think that design for this picture, or
No. What design means from the scientific point of view?
Okay, design is broad concept. I think that, and I think that design is maybe development of development of topic or maybe some device. It is exact. It is it can be exact structure of device, or maybe can maybe a certain liquid or some I don't know, maybe substance, and maybe you can take percent, but
Yeah.
for this development.
May I say, or am I right when saying that design is a structure of something that is connected with the outlook of something? Tatiana?
I'm sorry, could you repeat, please?
Am I right when saying that design of something is a structure of something that is connected with the outlook or outfit of something?
Yes.
So thank you, and certified designer here proved my opinion that design is something about both the structure, the internal of some gadget, of some process of some system, and to the outlook, to the outfit of the system. When we use a smartphone, we can look on the outer side of the smartphone, but the functionality of this phone is caused by the structure, but how the details are assembled in this gadget. And the same thing is about privacy, because again, not speaking about the rules of law or laws. Privacy exists now in gadgets, in systems and processes. And how we design these gadget systems or processes causes how our information, how our privacy is protected within these systems or processes. Have you seen the commercial of iPhones or other Apple products based on privacy issue? Advertisement of iPhone for privacy. No? Okay. That's one of the most prominent reflection of this privacy by design idea. privacy now is a competitional advantage. That something constructed private is more useful, more wishable by consumers, have more advantages from the comparing other goods, just because it's more private. iPhones said to be more private than Android phones, and that's why they cost more than Android phones. This idea called privacy by design was elaborated by another. She's not a lawyer. She's a psychologist. A very prominent woman in Canada, Anne Cavoukian. She stated these 7 foundation principles by so-called privacy by design. It means how to build, how to design systems that are private by its nature. Just to explain in brief the gist of his principles. First is proactive and reactive, preventative, not remedial. The idea of this principle is that it's very hard to eliminate or to improve any harm that is already caused to privacy. It's much easier, it's much cheaper to prevent any harm, not to use any means to get it out, to get rid of it, and to eliminate it. The second principle is privacy at the default setting. It means that by default, any setting of any computer system should be that information within the system is private. Again, it's just a default setting that may be changed by the user. For example, if you take your family photos, by default, these family photos shall be private. But if you want to share these photos with your family or maybe with a friend, you may change this default setting of being private to share with some members of your family. Maybe if you wanted to share this knowledge, for example, of your baby, making his or her first steps, and you want to share with all the world, then you may change the default setting of privacy to public, and that's shall be allowed to you and to any user of the system. But again, the default setting shall be private. Privacy embedded into design. That's very important, because often when designing any computer system, any software, any gadget, information protection and information security systems or modules are designed as standalone, not included into the design of the structure of the system. And that's not right in accordance with this privacy by design principles. Because this system, I mean the system of information security and the system of some service or some activity or some value made by this information system shall act as the one single system, not by the one system controlled or supervised or attached to the other systems. The fourth principle is full functionality, positive sum, not zero sum. Do you have any idea what positive sum or win-win case is? What's related to? Okay, what kind of theory is to describe what is win-win case? Any idea? Okay, have any of you ever heard about the game theory?
Yes, I know some issues about the game theory on artificial intelligence.
Great. And what is win-win case in game theory?
That the two players or the multiplayer all have scores. And not zero sum. So when I win 5 points, so all players will decrease 5 points. This is the zero sum case. But win-win, all the players will have a positive score, for example.
Okay. Yes, great.
Or in other words, when I make a step in the game, so I will earn points without decreasing them from the others.
Okay, great. There are two main kind of games: positive sum and zero sum. What is zero sum? It's a pretty card game. If you play cards with somebody, only one of you can win. It means the zero sum rules. One win, the other lose. Positive sum. It's a game, for example, when you order a pizza or order a beer for any other participants of the game. When you win or when you lose, no matter if you lose or not, or if you win, everyone will have a pizza or will have a beer. It's a positive sum game. And privacy protection in the information system shall in any case be positive sum game with the functionality of the system. For example, such system like iPhone, its main functionality is to make calls, to share messages, to share photos, to access some internet resources. It's the main functionality of this gadget. The aims of privacy protection is to do all these functions safely. The positive sum means, okay, let's talk about zero sum first. The zero sum means that you will always need to choose whether to use the functionality, whether to make the call, or whether to protect your privacy. If you make the call, if you will make a call, there is no privacy. If you choose privacy, you cannot make a call. It's a zero-sum game. From the other side, there will positive sum game is when your privacy is protected while you make a call. Your privacy is protected while you share a photo, etc. That's what this principle is about. End-to-end security, full life cycle protection. It means that from the point where some information is gathered up to the point where this information is used, it is protected by the same principles and by the same procedure, by the same level of protection. For example, if we're speaking about some messaging system, all the channels from the sender to the receiver shall be protected under the same level of protection. There shall not be some unprotected channels between, for example, two servers inside your network. There will be no backdoors. There shall be no backdoors to the information that can be used, for example, IT staff to maintain the system, etc. Full life cycle protection means that the one single level of data protection established throughout the information systems, throughout the life cycle of data. The sixth is visibility and transparency. It keeps it open. We will speak more about it tomorrow, but it's a matter of trust. People want to share the information with others, want to share the information with you, with your company, if they understand how it's processed, for what aims it's processed, etc., etc. The more transparent, the more visible your information processes are, the more trust people experience in your system. And the seventh principle is respect for users' privacy. Keep it user-centric, because everything is done on the IT market, is done up to the end for people, because any system, any well-protected, any high-protected system, any high-performance system made for the aims of the company itself cannot be sold to people, cannot be sold on the market, and is unsoldable. You cannot earn money from them. So the main thing to do in any design of information system, of gadget or information process, is to think about user, how it can be used, what are the interests of user, what kind of information shall be protected about the user in the system, etc., etc. Just to give you idea of this privacy by design theory, if you want to go into it deeply, and I really advise you to do so, you can go to the website privacybydesign.ca and follow Anne Kavukyan in YouTube or some other networks where she gives really thoughtful and powerful presentation of how it shall work. So please not forget its name, Anne Kavukyan. And I think it will be quite useful to you to get to know more about this privacy by design. Do you have any question about this slide? Okay, let's move further. Have you heard about Dolly Parton Challenge? What it is?
I heard about that, but I don't know that it's Dolly Parton Challenge. I know that someone will put a comic of himself for the 4 personalities of him on the 4 different websites. That LinkedIn is more professional and like that. Yeah, the 4 characteristics.
Yes, me too. Don't really like it with Dolly Parton. My favorite is about Army, but the Dolly Parton started it, and it's called Dolly Parton Challenge. It means how you or how any other person may look like in 4 social networks. One is
Yes.
for profession, second is for family, the third one is for glamour, etc. And the fourth is for some love or relations. And what this Dolly Parton Challenge showed that we have, almost all of us have at least 4 different personalities. And it's very, very important for the privacy reasons because of the concept called contextual integrity. It's the most modern concept of privacy, and I want to tell you a few words about this. The idea underlying this contextual integrity approach to privacy is that we, human, elaborate different personalities, different us, for different contexts. It means there is one Nikolai Dmitrich for my family, the other Nikolai Dmitrich for my lectures in the university here, the third Nikolai Dmitrich for my friends, etc., etc. There is certainly the fourth Nikolai Dmitrich when I go shopping, the fifth when I try to sleep in the aircraft, etc. And this function to elaborate different personalities for different contexts is very crucial for us being humans. It's one of the most important human characteristics at all. To tailor, it means to suit our behavior depending on our audience, depending on what we are interacting with child, with friends, with family, with employers, with the employees, with some people on the street, etc. And the main thing, the main restriction originating from this idea of different contexts and different personalities is not to mix any information from different contexts. It means the worst thing that can be done to a person regarding information about him or her is to move information from one audience, from one context to another. Just to give you an example, maybe you publish a photo from your party with friends, a little bit drunk, a little bit not well dressed, to your group of your friends in Facebook. There is nothing wrong, and there's nothing that can bring harm to you because all other friends were there on this party and they saw you in this image, and there is nothing that can make relations with a friend worse. Unlike this, if this photo is brought to your employer, it's not good because you do not behave like that during the work hours, and your employer may have not seen you in this way. Even worst thing, if when you apply, for example, to Skoltech scholarship, somebody deciding whether to not or to, whether to give or not to give the scholarship to you, see this photo. There are 3 different contexts, and moving from one to another will increase the harm that can be made to you by this very information. It's not harmful for the first context, it's much more harmful for the third context. So the thing is, in accordance to this approach, not to move information between the contexts, because it will result in restriction of our ability to construct our individual identity, and it's very harmful for us. And from this point, we need to say a few words about what is the harm, why it is all for, why the privacy is needed to be protected. Because any legislation and any system and any data collector will need to protect, to prevent us from any harm caused by disclosing information, collection of it, of use of it. And speaking about the position elaborated by Elise Groton, is another French lawyer. She states that there are 3 types of data procession. It means what can happen to data, and then 3 types of harm that can be inflicted by this. If the data is collected, the worst harm is that a person about whom data is collected does not feel well. It means a subjective harm. It's a kind of worry. It's a kind of feeling of being under surveillance, etc., etc. And the best way to prevent this harm is to make the collection process transparent. People, the data subject, the people, the person about whom the information is, shall be aware of what information is gathered, for what aims, for what reasons, and how it will be used in the future. In this case, no worry can occur and no harm from the collection of data can occur. The second way of processing is the disclosure of data. It means spreading of data for some other people, accountable or uncountable. And in this case, harm may be subjective. Again, a feeling of embarrassment or some humiliation itself. And I may also add to this position elaborated by Elise Groton that even in this case, harm may be objective, because there are a lot of examples for people being divorced under some private pictures are published. It's a kind of objective harm. People lost their families. And the third type of activity with the data is the use of data, is making some decision about data. In this case, harm will be objective for any reason. It's not given a credit from the bank, not employed for work, not granted a scholarship, etc., etc. It's quite an objective kind of harm, because a person may be deprived from money, from work, from study, from ability to travel, etc. And again, you may see here that the way to prevent this kind of harm is not to move the information between the contexts. What is in your family life shall stay in your family life. What's in work life shall stay in your work life. And that's the best way to prevent any harm caused to your privacy. Do you have any question regarding that? Because it's almost the final slide of my presentation here. So you may free to ask any question you have during this talk today. So that said, please, if you feel that it's not interesting to you what I'm talking about, if you don't understand because it's too legal or too or if I use words that may not be very familiar to you, please let me know, because my aim here is to give you some thoughts about privacy and how it works. Okay. I hope that tomorrow will be better, and for having a topic to discuss tomorrow, I'm giving you an assignment. I'll open it in your project management system today. It's very simple. Please describe any situation when you feel that your privacy was in danger. It means, yes, somewhere in the internet, some situation when you feel you're under surveillance, when your private information was spread by your friends or colleagues at work or your co-students, etc. I promise you not to violate your privacy, not to discuss your real cases, but it will show me what kind of privacy interests you experience. Okay, so that will be your assignment for tomorrow. Okay.
Okay. Yes. Thank you.
Okay.
I'm sorry, sorry, but I didn't understand what is exactly the homework. This question, so it's a theoretical or it's a special situation for
practical.
me.
It's very practical, related to you personally. For example, today I worried about my privacy when I saw my neighbor staring at me from the window, which is so close that he could saw me going naked through my bedroom. That's a kind of example.
It's a story about me, yes.
Yes, it's a story about me, very brief, just to give me some context of what you worry about in your own privacy. So we can talk about it more close to your practical interest.
Okay, thank you.
Please be honest. I promise not to reveal any kind of a privacy information. It's just for my course to make it more interesting to you.
I'm sorry. I right understand that we must not resolve the issue of protection for our privacy, only our experience. Yes.
Yes, just your feelings and your experience, not any solution for it.
Okay, thank you.
It will be told at the start of tomorrow's meeting, right?
No, you will need to go to your Canvas. It's your
Yes.
learning management system to write it
Okay.
down there, so that I can see it in your assignment.
Okay.
So it's a kind of an essay, yes?
It's a kind of very small essay, just 100 to 200 words.
Okay.
Thank you.
Okay, great. Then see you tomorrow. We will discuss the personal data protection. Bye.
Yes, thank you very much.
Goodbye.
Thank
Thank you.
you.